The judgment was entered on the morning of April 18th, Federal Courthouse, Eastern District of Tennessee, Greene County. Case number 26-CV-00417. The presiding judge was the Honorable Margaret Calloway, 29 years on the federal bench. The hearing lasted 43 minutes. The award against Continental Asset Recovery Group LLC and its parent holding company was $14,210,000, punitive and compensatory combined, plus attorney's fees, plus a permanent injunction barring the firm from initiating any further claims against properties in 3 counties. The man who collected that judgment was Earl Hammond, 76 years old, 5'9", 161 pounds. He owned 407 acres of farmland in Greene County, Tennessee, on land his grandfather had purchased in 1937 and his father had expanded twice, in 1958 and 1964. Earl walked out of the courthouse that morning carrying a single metal box, black, roughly the size of a small toolbox, 2 latches. Inside, organized by year and labeled in his mother's handwriting, were 48 years of records. One of those records was a single letter, dated September 14, 1964, 1 page, typewritten, signed in fountain pen by a man who had been dead for 31 years. That letter cost Continental $14 million. Here is how it started. Earl Hammond had inherited the farm in 1979, the year his father died of a stroke at 68. His father had made him sit at the kitchen table the previous Christmas and walk him through what he called the system. The system was the metal boxes in the upstairs closet, 12 of them at the time. His mother had organized them. Every receipt, every contract, every letter, every payment record, every survey, every tax statement, every land transaction since 1937, filed by year, labeled in her hand. His father said one thing to him that afternoon. He said, "Earl, the only thing that protects this land is paper. You keep every piece of paper. You don't decide what matters, you let the paper decide later." Earl had kept that promise for 46 years. His mother had passed in 1991, his father in 1979, his wife Catherine in 2014, after 39 years of marriage. Catherine had taken over the boxes from his mother in 1985 and maintained them with the same precision until her diagnosis. The last entry in her handwriting was dated March 9, 2014. The boxes now numbered 19. They occupied 2 full shelves of the upstairs closet. Earl added to them himself in handwriting that did not match his wife's or his mother's, but in the same system, with the same labels in the same order. He was the 3rd generation to maintain them. The letter from Continental Asset Recovery Group LLC arrived on January 7, 2026. Plain manila envelope. Return address in Wilmington, Delaware. Inside, 3 pages of dense legal text, a claim notice, and a deadline. The claim asserted that an agricultural development loan extended to Earl's father in 1964 in the amount of $42,000 had been securitized and transferred to a successor entity in 1971, and again in 1989, and again in 2003, and that under a recent portfolio acquisition, Continental had taken possession of the residual rights. The claim asserted that the loan had never been properly closed in the federal record system, that accumulated interest under the original promissory note now totaled $487,000, and that Continental was prepared to initiate foreclosure proceedings against the 407 acres unless the balance was settled within 30 days. The deadline was February 6th. Earl read the letter twice. He set it on the kitchen table. He went upstairs to the closet and pulled down the box labeled 1964. He did not open it that day. He brought it down. He set it on the kitchen table next to the letter. He left them both there overnight. Continental Asset Recovery Group LLC had been formed in 2019. It was a Delaware limited liability company with no employees of its own and no physical office. It was managed by a private equity holding firm based in Greenwich, Connecticut, which itself was a subsidiary of a larger fund whose investors were not publicly disclosed. Continental's stated purpose was the acquisition of distressed and orphaned legacy debt instruments. Its operating model was straightforward. It purchased portfolios of old loans, often for less than 2 cents on the dollar, from institutions that had absorbed the original lenders through 40 years of consolidations. It then identified properties whose value substantially exceeded the original loan amount. It sent demand letters. It collected from those who paid. It foreclosed on those who did not. In 2025, Continental had initiated 483 claims across 11 states. 312 had resulted in payment. 61 had resulted in foreclosure or property surrender. The remaining were either pending or settled below the original demand. The representative who arrived at Earl's door on January 19th was named Marcus Chen, 29 years old, suit, no tie. He carried a leather portfolio. He drove a black SUV with rental plates. He had been in the field for Continental for 16 months. He spent 11 minutes at Earl's front door. The conversation was recorded by Earl on a small device on the porch table, which Earl had begun using after Catherine's death for medical appointments and which he had not removed. Chen explained the claim. He explained the deadline. He explained that Continental was, in his words, prepared to be reasonable. He offered a settlement of $290,000 payable within 15 days in exchange for full release of all claims. Earl asked him one question. He asked whether Continental had reviewed the original 1964 loan documents. Chen said the firm had reviewed all relevant materials transferred under the portfolio acquisition. Earl asked him a second question. He asked whether Continental had a copy of the closure letter. Chen said he was not aware of any closure letter and that in any case, the absence of a recorded closure in the federal system was the legal basis for the claim. Earl thanked him. He closed the door. The closure letter was in box 1964. The lawyer Earl retained on January 22nd was named Beatrice Holloway. She was 58 years old. She had practiced in Greenville, Tennessee for 27 years. She had handled 3 previous cases involving Continental and had lost 2 of them on procedural grounds before the substantive evidence could be heard. She read the demand letter. She read the chain of transfers Continental had asserted. She looked at Earl across her desk. Mr. Hammond, I'm going to be direct with you. Continental does this professionally. They have lawyers in 3 states who do nothing but defend these claims. The law is bad on old debt because the law assumes records were kept. When records weren't kept, the borrower usually loses, even when the borrower is right. Do you have anything from 1964 that proves the loan was paid off? Earl set the metal box on her desk. He turned the latches. He opened the lid. The box contained 114 documents. Earl had organized them the night before in 3 groups: bank statements, receipts, correspondence. He removed a single sheet from the correspondence group. It had been folded once and was filed in a clear sleeve. He passed it across the desk. Holloway read it. She read it a second time. She put on her reading glasses, which she had not been wearing, and read it a third time. The letter was dated September 14th, 1964. It was on the letterhead of First National Bank of Greenville, the original lender. It was addressed to Mr. Walter Hammond, Earl's father. It was signed by Mr. Howard Brennan, branch president, who had died in 1995. The letter stated that the agricultural development loan in the amount of $42,000, originally executed on March 11, 1964, had been paid in full as of September 12, 1964. It stated that the promissory note had been marked satisfied and returned to the borrower. It stated that the lien against the property had been released, and the release filed with the Greene County Register of Deeds on September 13th. It thanked Mr. Hammond for his business. The letter was signed in blue fountain pen. Holloway looked up from the letter. Mr. Hammond, do you know what this is? My father said it was the most important piece of paper in that box. He was right. She set the letter down carefully on a clean blotter. Continental has built a claim on the assertion that this loan was never closed. They have done so based on records that show no closure in the federal system. They have either failed to find this letter or chosen not to look for it. Either way, the moment we file this letter into the court record, their entire claim collapses. And it does worse than collapse. Worse how? Mr. Hammond, when a debt collector pursues a claim they know or should have known to be invalid, that crosses from civil into something else. There are federal statutes. There are state consumer protection laws. There is the matter of every other claim Continental has filed in the last 6 years on the basis of similar gaps in the federal record. If we can show this as a pattern, the damages are not just compensatory, they are punitive. And punitive damages, in a case like this, are not measured against what they tried to take from you. They are measured against the size of the firm that tried to take it. Earl said nothing. Holloway closed the lid of the metal box gently, both hands on the latches. Mr. Hammond, I would like to file this case in federal court, not state, federal. And I would like to seek discovery of every claim Continental has filed in the last 6 years. If the pattern is what I suspect, we are not asking for $290,000. We are asking for everything. Earl thought about it for a long time. Catherine kept the box for 29 years, he said. My mother kept it for 48 before that. My father told me in 1978 that the only thing that protects the land is paper. I don't want money. I want this firm to stop doing this to other people. Then we file. File it. The complaint was filed February 4th, 2 days before Continental's deadline. The closure letter was attached as Exhibit A. The recorded conversation with Marcus Chen was attached as Exhibit B. The discovery motion was filed the same day. Continental's response was filed 17 days later. It was a motion to dismiss on procedural grounds. The motion did not address the closure letter directly. It argued that the federal records gap was the controlling document, and that any private correspondence between the original parties was inadmissible without authentication. Holloway responded by subpoenaing the Greene County Register of Deeds. The lien release filed on September 13, 1964, was still in the courthouse archives. It had been filed on file card number 3117 and microfilmed in 1981. The original card and the microfilm both confirmed the release. The motion to dismiss was denied on March 6th. The discovery order was granted on March 11th. Continental's records, produced under subpoena over the next 4 weeks, showed that the firm had filed 483 claims across 11 states using the same federal records gap theory. Of those, 61 had resulted in property loss for the defendant. In 19 of those 61 cases, county records contained closure documentation that Continental had either failed to obtain or, in 7 documented cases, had obtained and not disclosed. Holloway filed a motion for summary judgment with a request for punitive damages. The trial date was set for April 18th. Continental's lead counsel was a man named Theodore Vance, 52, of a firm in Atlanta with 73 lawyers. He spent 22 minutes in his opening argument on the procedural complexity of legacy debt portfolios and the difficulty of establishing chains of custody across 6 decades. He used the phrase legacy artifact 11 times to describe the closure letter. Holloway's opening argument was 3 sentences. She said, "Your Honor, in 1964, a man named Howard Brennan signed a letter saying this loan was paid in full. In 2026, a firm that did not exist when he signed it sent Mr. Hammond a demand for $487,000 on the assertion that it had not been. The letter has been in a metal box for 62 years, and that is the only fact that matters in this courtroom today." Judge Calloway read the letter in silence. The room waited. She read the lien release card from 1964. She looked at the sheet of 19 confirmed cases of suppressed closure documentation. She asked Vance one question. She asked whether Continental had searched the Greene County Register of Deeds before filing the demand against Mr. Hammond. Vance said the firm relied on federal record databases as a matter of operational protocol. Calloway asked the question again. Had anyone at Continental searched the Greene County records? Vance said no. The judgment was entered 43 minutes later. $14,210,000. The injunction was entered the same afternoon. Earl walked out of the courthouse at 11:14 a.m. He carried the metal box back to the truck. He drove the 18 miles home alone. He did not stop on the way. When he got to the house, he carried the box upstairs. He put the closure letter back in its clear sleeve. He placed the sleeve back in the correspondence group, in its proper position by date. He closed the lid. He turned the latches. He set the box back on the shelf in the upstairs closet, in its place between 1963 and 1965. He went back downstairs. He went out to the back porch. He sat in the chair Catherine had picked out in 2008. He looked across the back pasture toward the line of trees that marked the eastern boundary of his grandfather's original purchase. Some things are kept because they matter, and some things matter only because they were kept. The difference in the end is the hand that filed them, and the hand that filed them after that, and the third hand that did not throw any of it away. Tell me in the comments, would you have settled for $290,000 and walked away clean? Or would you have filed and gone to trial like Earl did? I'll see you next story. Paste your script.